Hello friends, my name is Dr. Devaruti Haldar and in this session I am going to discuss about the intermediary liability. Please note that in my earlier videos and also in my earlier video lectures I have already discussed about what is a website, what is an intermediary, what is the difference between the two. This lecture is the first of the series related to the intermediary liability. So in this lecture, I'm going to start discussions on the intermediary liability from the Indian perspective. First of all, let us understand what is the meaning of intermediary. As I discussed in my earlier videos, intermediary and websites are actually different. The definition of the term intermediary has been dealt with under Section 2W of the Information Technology Act 2000, which is amended in 2008. Saying this, I mean to say that the definition of the term intermediary was included in the Statute Information Technology Act only through the 2008 amendment. Intermediary, as per section 2W, means intermediary with respect to any particular electronic record, means any person who, on behalf of another person, receives, stores, or transmits that record or provides any service with respect to that record and includes many other stakeholders, which includes telecom service providers, network service providers, internet service providers, web hosting service providers, search engines, online payment sites, online auction sites, online marketplaces, and cyber cafe. As we understand from this definition, intermediary term is very broad and there are different kinds of intermediary that we can see in this very definition. Now, we are going to discuss about the website liability. Section 79 of the Information Technology Act discusses about the immunity clause for every website. That means for every intermediary who may have a website or the websites which are connected with specific intermediaries. What we get to see from Section 79. Intermediaries will not be eligible for any immunity, especially third party liability, especially when their websites, their services, their web pages, etc., are misused for committing any offense by any person. So, what are these grounds when the intermediary and the websites will not be getting the immunity veil? Number one, when such websites connected with the intermediaries knowingly harbor offensive contents, that means immediately uploading certain contents. If somebody gets to see that these contents are offensive, they report such contents, and these intermediaries connected with the websites, they know that these are offensive contents but they are not removing these contents, they basically will not be eligible for any third party liability immunity and they will be held liable under section 79 of the Information Technology Act. The second ground when such immunity will not be available to the social media sites or for example intermediaries, etc., when even after even after getting the reports about certain offensive contents that had been uploaded on their pages, on their websites, etc., by another person, and when the victim or any bystander also reports the matter to the intermediary, even after getting that report, they do not remove the contents post reporting. This is something which I have seen is very common with many persons, especially victims, women victims, child victims, etc., when they actually encounter certain kinds of offensive behavior from others and they report the matter to the intermediaries, and the intermediaries may return to the victims, that is the reporters, by stating that this does not violate their policies, but actually in reality that actually does. So in such cases, not removing the contents post reporting may be considered as one of the very valid grounds where Section 79 of the Information Technology Act stops operating and the intermediary becomes liable under Section 79 of the Information Technology Act. The third ground where this immunity veil will not be available to the intermediaries is when intentionally uploading the offensive contents is permitted by the intermediaries or the intermediaries themselves. Like in the previous box, we just got to see knowingly they harbor offensive contents. The third point here is that they are intentionally uploading the offensive contents. In such cases, the intermediary and the websites connected with them will be considered directly liable for any sort of punishments under the laws existing in the country. The fourth point or the fourth issue when the intermediaries will not be liable or sorry when the intermediaries will not be eligible for the immunity veil is when the intermediary is sheltering perpetrators intentionally. What does it mean? If we see all 4 points in a very holistic fashion, we would be getting the understanding in this regard. That means the intermediary, which is connected with the website where the offensive content has been uploaded, knowingly harbors those offensive contents. That means keeps these offensive contents, knowing very well that these are offensive contents. The intermediaries connected with the websites, they do not remove the contents post reporting. That means these contents have been reported to the intermediaries as offensive, but they do not remove these contents or refuse to remove these contents. Third issue we get to see, they are intentionally uploading certain offensive contents and that are visible to the public or that are directly targeted to an individual or group of individuals. And the fourth that we are right now talking about is they are sheltering the perpetrators intentionally. The intermediaries are sheltering the perpetrators means even if the criminal justice machinery, the police, the courts, etc., are trying to pierce the immunity veil, are trying to ask the intermediary to expose the content creator, uploader, etc., who has uploaded some offensive content, but the intermediary is not giving or exposing the uploader, not exposing the content owner, not exposing the profile owner who has uploaded such offensive contents, and at the same time the intermediary is trying to shield that perpetrator by stating that they are not supposed to do it, especially when such contents are visible in other countries and they are governed by some other laws belonging to some other jurisdictions. The very important thing that we need to discuss about our upcoming lectures on Information Technology Intermediary Guidelines and Digital Media Ethics Code Rule 2021 is part 2, which discusses about due diligence by intermediaries and grievance redressal mechanism. Some of these sections under this part 2 are very important and also very interesting. Section 3, subclause 1 discusses about due diligence to be followed by the intermediaries. This is again supported by one more section, that is section 4 of part 2 of Information Technology Intermediary Guidelines and Digital Media Ethics Code Rules 2021, which discusses about additional due diligence to be observed by the intermediary. As we understand, if the intermediaries follow certain due diligence related issues, then only they can be availing certain immunity clauses. Hence, these two sections are going to be very important in our forthcoming discussion. Second, we get to see section 3, subclause 2, which speaks about grievance redressal mechanism of intermediaries. Yes, one of the very important issue that needs to be discussed when we are talking about the liability of the intermediaries is how they are managing the grievances from the subscribers, from the users. Hence, this rule 2021 also emphasizes on the grievance redressal mechanism of the intermediaries. Last but not the least that we are going to discuss in our upcoming lectures is about additional due diligence to be observed by an intermediary in relation to the news and current affairs content. That means additional due diligence especially relating to the fake news. So in my next video session, we are going to elaborately discuss about all these issues that we just now saw. If you have liked this video, please click like on this. Please subscribe to my video sessions. Thank you so much.